Understanding product liability lawsuits. So we bring products into our homes every day, trusting that they're safe for our families. But what happens when that trust is broken? What happens when a product that should protect us actually harms us or a loved one? Welcome back to the Ask Rusty Law podcast. I'm Rusty Messer with Big River Trial Attorneys right here in Baton Rouge, Louisiana. So today we're going to talk about something that touches every single one of us: product liability lawsuits. So I want to walk you through what a product liability lawsuit is, what you need to prove to win one, and what kinds of compensation you might be able to recover. And to make this real, we're going to look at a tragic case that made national headlines. It's an IKEA furniture tip-over death that resulted in one of the largest wrongful death settlements for a child in U.S. history. So let's start with basics. What exactly is a product liability lawsuit? So a product liability lawsuit is a legal claim brought when someone is injured or killed by a defective product or a dangerous product. And so these cases hold manufacturers, distributors, and retailers accountable for putting these unsafe products into the marketplace. Now, there are generally three types of product defects that can form the basis of a product liability claim. So the first are manufacturing defects. So this is when something goes wrong in the production process and the product that reaches the consumer isn't made the way it was designed to be. So maybe one batch of car seats has a faulty buckle, or a particular run of cribs has a weak slat that can break. The second type are design defects, and this is when there's just something fundamentally wrong with how the product was conceived from the beginning. So the entire product line is dangerous because of how it was designed. So even if it was manufactured perfectly, and this is often what we see in furniture tip-over cases, the design itself makes the product unstable. And the third type is a failure to warn or an inadequate warning. So sometimes a product might have an inherent danger that just can't be completely eliminated through design or however, but the manufacturer fails to properly warn consumers about those dangers or how to use the products safely. Now, product liability law exists because we have a fundamental belief in this country that companies should be held responsible when they put dangerous products on the market. So manufacturers make money from selling their products, so they should bear the cost when the products cause harm. Let me tell you about a case that illustrates just how devastating defective products can be and how important these lawsuits are for protecting families. So we're going to talk about the IKEA Malm dresser case. And it's actually a series of cases. It involved a series of tragic deaths of young children between 2014 and 2017. So multiple toddlers were killed when IKEA dressers tipped over and crushed them. Now, one of these victims was a 2-year-old out of California. In May of 2017, a 3-drawer IKEA Malm dresser tipped over and fell onto this child and killed him. Here's what makes this story even more tragic. The exact dresser model had been recalled a year earlier, so in June of 2016. But this child's parents didn't receive any notification about the recall, and they should have received notification because they were members of IKEA's loyalty program. So IKEA had their contact information. IKEA had their purchase history. IKEA knew that they had bought that dresser back in 2008, but IKEA never sent them a warning letter, never sent them an email, nothing. And so before this child died, there had already been other deaths. In fact, IKEA had already settled lawsuits with 3 other families for $50 million. And in December of 2016, 5 months before the child was killed in California, the company knew about the dangers. They knew children were dying, but they didn't do enough to get these dangerous dressers out of people's homes. So let me give you some perspective on the scope of the problem. The 2016 recall involved 17.3 million dressers. That's not a typo. 17.3 million. And you know how many of those dressers IKEA actually got back through refunds by June of 2019? Only 400,000. That's less than 3%. The problem was clear. The Malm dressers didn't meet the manufacturer. The problem was clear. The Malm dressers didn't meet the furniture industry's own voluntary safety standards. Those standards required that dressers taller than 30 inches remain stable even when a 50-pound weight was hanging on an open drawer. The IKEA dressers failed that test. They were inherently unstable and prone to tipping. All it took to prevent the dressers from tipping over was a cheap plastic strap that would hold the dresser to the wall. Now let's talk about what it takes to actually win a product liability suit. So looking at the IKEA case gives us a perfect roadmap for understanding these elements. Element 1 is that you have to prove the product was defective. You have to prove there was actually something wrong with the product. In the IKEA case, this wasn't straightforward. The dressers didn't meet industry standards. In the IKEA case, this was straightforward. The dressers didn't meet industry standards. They were top-heavy and they were unstable. When children climbed on them or pulled out the drawers, they would tip over. So the design itself was defective, and these dressers were dangerous by their very nature. Element 2 is that the defect caused the injury. So you need to show that the defect caused the harm, right? So in the case of the child in California, the unstable dresser tipped over and fell on him, causing his death. This defect wasn't theoretical. It was an actual cause of the tragedy. In just about every product liability case, you are going to need an expert who can testify about why the product did not meet specifications and what alternative design was available or how the product was defective. And the third element is that the product was being used as intended. So the injured person must have been using the product in a reasonably foreseeable way. Now, manufacturers sometimes try to argue that the victim was misusing the product, but in the IKEA cases, children climbing on or opening dresser drawers is completely foreseeable. That's what young children do, right? So any furniture company knows that kids interact with furniture and dressers need to be stable enough to handle that normal everyday use. Element 4 is that the company knew or should have known about the danger. This is where the IKEA case gets particularly damning. So IKEA had reports of death and injuries going back for years. They knew about the problems as early as 2014 when the first deaths occurred. In fact, they'd received reports of deaths dating back to 1989 involving their furniture. And by the time the child died in California in 2017, the danger was very well documented. So the lawsuit alleged that IKEA not only knew about the dangers, but it also failed to commit sufficient resources to warn its consumers. So they initiated a repair program in 2015 offering the free wall anchors. Then they did a recall in 2016, but their efforts were, in the words of one former Consumer Product Safety Commissioner, absolutely abysmal. So the fifth element is a failure to warn. So even if a product has some inherent dangers, companies have a duty to adequately warn consumers and provide proper instructions for safe use. IKEA's warning efforts were severely lacking. So they offered the wall anchors as a solution, but the research showed that 73% of Americans never anchor their furniture because it requires power tools, maybe carpentry skills, and sometimes the landlord just won't let you put stuff on the wall like that. So even when the anchors were installed, the dressers would still sometimes fall over. So sometimes the anchors would fail, and this would pull out the drywall, or they would come detached from the back of the dresser. So more importantly, IKEA failed to reach the very people who had bought their products. So they had the customer information, they had the purchase histories, but they didn't use that data to send direct warnings to customers who owned the recalled dressers. In 2020, IKEA agreed to pay the family of the child in California $46 million. And legal experts believe this was the largest wrongful death settlement for a child in United States history at that time. So why was the settlement so large? According to the lawyers who represented the family, it was because IKEA did not conduct its recall effectively. The company had the means to contact the customers directly, but it chose not to. They had already paid out $50 million to 3 other families just months before, yet they still didn't do enough to prevent another death. So the settlement also included more than just money. So IKEA agreed to expand its outreach efforts to notify people about the recall of dressers. They committed to meeting with a group called Parents Against Tipovers, right? And this is a group formed by families who have lost children to furniture tipovers. And the family of the child who was killed donated $1 million from their settlement to consumer safety organizations to continue the fight against dangerous and defective furniture. Now, some people hear about large settlements like this and they think, that seems excessive. But let me tell you why these cases are absolutely essential. So a former executive director of the Consumer Product Safety Administration put it perfectly when she said the settlement shows that without a doubt, the strong and effective consumer protection requires government regulation and private enforcement of the laws through personal injury lawsuits, right? We cannot rely on just one or the other. Here's the reality. Government agencies like the CPSC, they're understaffed, they're underfunded. They oversee more than 15,000 different types of consumer products. They can't catch everything, right? They can't catch every dangerous product, and they can't force every company to do effective recalls. So private lawsuits fill in that gap. When companies know they'll face massive financial consequences for putting dangerous products on the market, they have a powerful incentive to prioritize safety. And when companies know they'll be held accountable and responsible for ineffective recalls, they invest more resources in making sure consumers are actually warned. The IKEA case also shows how important it is that companies can't just issue a recall and walk away. IKEA's efforts were woefully inadequate. We're talking about 17.3 million recalled dressers. They only managed to get back a tiny fraction. So a recall is meaningless if consumers don't even know about it. So since these cases and the settlements, there's been a push for stronger legislation. So you get consumer advocates. They backed a bill called the STURDY Act that stands for Stop Tipovers of Unstable, Risky Dressers of Youth. The bill would require the CPSC to create a mandatory federal safety standard for dressers, and that would be tougher than the voluntary industry standards. And because we've seen voluntary standards aren't enough. There was a voluntary standard in place for IKEA, but they weren't following it. So when children's lives are at stake, they need to do more. So what should you take away from all of this? First, if you or a loved one has been injured by a defective product, you might have a legal claim. Don't assume that because a company is big or because the product was cheap or inexpensive, that you don't have rights. Product liability laws exist specifically to protect consumers from dangerous products, regardless of who made them and regardless of how much they cost. Second, document everything. Keep the product if possible. Take photographs of your injuries. Keep all of your medical records and your receipts. Get witness statements if anyone saw what happened. This evidence can be crucial for proving your case later on down the road. Third, check for recalls. The CPSC maintains a database of recalled products at cpsc.gov. So if you have furniture, especially children's furniture or tall dressers, check whether it's been recalled. And if it has, take the recall seriously. Don't wait to get the product out of your house or properly secured. Fourth, understand that these cases can be complex. Product liability lawsuits often involve expert testimony about engineers, design, industry standards, maybe safety testing. So you need an attorney who has experience handling these types of cases and who has the resources to take on large manufacturers. And like I've said before, this is probably not your neighbor's nephew that just graduated law school. Finally, know that there are time limits for filing these claims. In Louisiana, you generally have 1 year from the date of injury, 2 years now after some recent legislation, and this is also the same for wrongful deaths. Texas also has a 2-year statute of limitations. But these deadlines are strict. So if you think you have a case, don't delay in seeking legal advice. The IKEA furniture tip-over cases are heartbreaking, but they're also instructive. They show us how product liability law works, what it takes to prove these cases, and why substantial damage awards are sometimes necessary to protect consumers and prevent future tragedies by forcing companies to do what they are supposed to do when they know they're going to be held accountable. So we hope you've enjoyed this episode of the Ask Rusty podcast. If you found it informative, if you found it useful, please like our channel. Please subscribe. Share it with someone that you know who might need this information. And as always, stay informed and stay safe.